In this video, I want to explain why the administrative state as it exists today is an entirely and profoundly unlawful and unconstitutional structure. As Columbia Law professor Philip Hamburger says in his book, administrative law is not only prohibited by the Constitution, but it is specifically the kind of thing that the Constitution was designed to prevent, and has become the greatest threat to our liberty.
I view it as the leading threat to civil liberties of our era.
Now, this video is a bit long, but you'll want to stay tuned to the end, because at the end of this, I give a very interesting real-life example of an administrative agency committing their fraud and crimes against an ordinary American. Many people are aware that our nation has gone astray from its founding principles and from constitutional rule, but they do not understand why or how this has happened. Now, if you begin examining the way our government currently operates, you can easily see that what is called the administrative state, which has grown in size and power over the last 150 years, is a huge part of the problem. The administrative state consists of all the administrative federal and state agencies, often with three-letter abbreviations, such as the FBI, the CDC, the FDA, the NHS, the DOJ, the EPA, the FAA, the FCC.
The administrative state. That collection of bureaucrats, agencies, and unelected rulemaking bodies whose decrees govern more and more of our lives.
The administrative state is essentially an unlawful fourth branch of government which unlawfully combines the powers of all three branches of government in one branch, thus violating the point of the separation of powers. Also, it unlawfully exercises each of these powers. Only the legislative branch can make law, but the administrative state is making law, which is called administrative law. Only the executive branch can enforce the law, but the administrative state is engaged in law enforcement. Only the judicial branch can adjudicate. But the administrative state has its own courts, called administrative courts, and its own judges. All of this is profoundly unlawful, and yet it has continued for decades, and it is only growing. Recently, in his interview with Donald Trump, Tucker Carlson asked a question highlighting the unlawfulness of the administrative state.
Why should EPA, no one at EPA was elected by anybody, why do they have the power to decide how much water your washing machine uses? Shouldn't Congress in a democracy get to vote on that?
The January 6th shaman guy. In his view, the administrative state is the deep state.
The bureaucracy, the deep state. The deep state is comprised of all three branches of government, legislative, judicial, and executive, being consolidated into a single branch of government that is constituting a fourth branch of government. And this is what the founders defined as tyranny. That's why they split the branches up. The bureaucracy, these bureaucratic agencies, which there are over 500 of them that are in charge with regulating commerce, okay? They write the regulations for commerce. In other words, they're writing a form of law, okay? And then they have their own law enforcement for their agency that enforce those regulations. So that's executive. So now you got legislative, you got executive, and they have their own administrative courts that are outside of the federal court system. That's judicial. That's tyranny. If somebody that's wearing horns and face paint can understand the problems of the world and explain them more simply than somebody that's running for president, we have a problem.
I agree.
However, shaman guy is oversimplifying things because the administrative state itself is not synonymous with the deep state. First of all, the deep state is not just American. It is global. It is a global crime syndicate. As we know, we have cabal criminals in Congress. We have cabal criminals in governor positions. We have cabal criminals in state legislatures. We have cabal criminals in the judicial system sitting as judges. We have cabal criminals in law enforcement. Now, in this video, I want to go into some of the details about why the administrative state and administrative law are profoundly unlawful. And in doing this, I will be using the work of Philip Hamburger, who is a Columbia University professor of law.
Administrative power does not match the powers authorized by the Constitution. The Constitution, of course, authorizes three types of power: legislative power in Congress, executive power in the president and its subordinates, and judicial power in the courts. What then is administrative power? Is it a fourth sort of power? It's often said so by some of my colleagues. But then how is it constitutional?
Hamburger nails the point there because administrative power is not constitutional. And this is very easy to see, and yet we have a lot of people making excuses for why this is not the case. English kings were bound to govern through the law, but they didn't like that. They wanted to go outside the law so they would have more power. We can intuitively understand why this is so. Wouldn't powerful people always like to get more and more power? This is an innate problem in human existence, and it is therefore something that governments always have to protect the people against.
We need to begin with prerogative power. English kings were widely expected to rule through law. They had parliament for making law and courts of law for adjudicating cases. And kings were expected to govern through the acts of these bodies. But kings, of course, were often discontent with governing through law. They wanted control, more control than they could get when relying on their legislature and judicial acts. And so they therefore often acted on their own, not through law, but through royal or prerogative power.
Hamburger goes on to talk about how when kings exercised power outside the law, it was called prerogative power. And he explains how prerogative power is the basis of our modern administrative state's unlawful and unconstitutional use of power. The administrative state is essentially a return to a form of absolute power, which is the basis of any totalitarian system.
The power ordinarily exercised through law thus was evaded when kings acted through prerogative power. Prerogative power thus was, you could say, the predecessor of administrative power. Prerogative power was the personal power of kings. Administrative power is the bureaucratized power of the state. But otherwise, they're very similar. Both have been evasions of law. Consider these prerogative evasions, and they should sound familiar if you know anything about administrative evasions. Ordinarily, kings bound their subjects through statutes, but with their prerogative power, they bound them through proclamations or decrees, what we call rules and regulations. Ordinarily, kings repealed old statutes by obtaining new statutes, but through their prerogative power, they issued prerogative dispensations and suspensions, what we call waivers. Ordinarily, kings could enforce law only through the courts of law, but with prerogative power, they enforced their extralegal commands in their own prerogative courts: King's Council, Star Chamber, High Commission. We have the equivalent of these. They're called our administrative agencies. Ordinarily, the kings had to work through courts of law with the due process of law. But in their prerogative courts, they could use civilian inquisitorial process, what we call administrative process. Ordinarily, the judges resolved disputes about royal power, but on account of the prerogative power, kings expected deference from the judges. They expected deference to prerogative regulations, to prerogative interpretations of statutes, and to prerogative fact-finding. And interestingly, though, unlike today, the judges then generally refused to defer. Last but not least, prerogative power evaded English divisions of power. Although the English did not yet have a full separation of powers, they had a basic division of powers. Parliament made law, the courts adjudicated it, the king exercised force. Nonetheless, when kings act through their prerogative power, they or the prerogative courts exercise all government powers. For example, the Star Chamber made regulations, prosecuted infractions, and adjudicated them. It sounds just like a modern agency. Evidently, prerogative power was a means of evading government through law. It was a way of exercising it outside the law. And just as kings evaded law with prerogative power, the executive now evades law with administrative power.
What should be very interesting and deeply concerning to us is that the English Parliament 3 centuries ago abolished the king's use of prerogative power, meaning they told the king, you cannot govern outside the law. In essence, 21st century America has a massive structure allowing use of power outside of the Constitution, outside of the rule of law, of the kind that was abolished in England 3 centuries ago. The administrative state creates law, and it does so through unelected people, which is another violation. It's the violation of the founding principle of representative government in a constitutional government, meaning that the people must give their consent to the government to create law. The lawmaking of the administrative state is done totally without consent of the governed, and as such is profoundly unconstitutional.
Right. So one can find this in most agencies. Agencies get a loose instruction from Congress, for example, make air clean. And then the agency will define clean and make a host of rules requiring how we should regulate our lives and our businesses and our farms and the rest. These rules are not enacted by Congress, and that's why this is really a civil liberties problem. We should be able to live under rules made by the folks we elect. That's the whole point of having a republic.
Hamburger also points out how not only is the administrative state evading the Constitution, it also creates law through constant new evasions even of its own rules. Thus, the administrative state involves law-breaking on top of law-breaking on top of law-breaking.
Gary Lawson, a scholar at Boston University, has noted the rise and rise of the administrative state. The administrative power always seems to expand, whether under Democrats or Republicans. And I think the reason for this is one has to think of administrative power really as an evasion of regular pathways. First, an evasion of constitutional pathways for making law and adjudicating, and then even an evasion of administrative pathways. You get ever less formal modes of binding Americans, of commanding Americans and telling them what to do. This is just the natural progress, I think, of power, always to escape its limits.
Is there, why do people even bother coming up with a constitution if immediately they're going to start saying, no, we're not going to actually live by the rules that we just created. We're going to arrogate more and more power into fewer and fewer hands.
Right. So that's actually precisely why we have a constitution, because we can appeal to it publicly and in litigation to defend our freedom. And the danger is the fibs we tell ourselves, and that the judges, unfortunately, have come to believe that you don't really need jury rights. The due process is satisfied by an administrative process, that a rule is no different really than an enacted statute. And so what we need to do is actually just be honest. An administrative rule is not a statute adopted by our representatives, and it is not legally binding. An administrative adjudication has no due process. Due process comes from the courts. It has no jury. And when the judges go out of their way to accommodate all of this, they end up corrupting their own processes.
The administrative courts, which are an unlawful power grab away from the judicial system, also violate the Constitution in that they fail to offer due process. They do not have real judges. They do not have jury. Now, you may say, well, if administrative power is unconstitutional, why doesn't the Supreme Court ban it? The judicial system actually gives deference to administrative states, wherein it recognizes they're not operating constitutionally, but exempts them by saying, well, you're basically not running a constitutional structure there, so I guess you don't have to follow the Constitution. Whereas our judicial system will make decisions that Congress or state legislatures have violated the law, it is reluctant to do the same for any administrative agency. The result of this is that the law of the land is not supreme, but the unlawful administrative agencies are supreme. Also, administrative agencies violate the law in another way. They give themselves the power to exempt people from the laws that they create. In other words, through administrative waivers, they say to basically any person or corporation or group that they please, well, we have this law, but you don't have to follow it. Everybody else does, though. This is done nowhere else in government. No part of government has the authority to exempt someone from the law. There are 2 other areas of unlawfulness I'll mention before going to my real-life example. The first is licensing. How in the world did administrative agencies give themselves permission to decide if any of us can do business? They don't have that authority. Finally, given all the huge amount of unlawfulness in these agencies, you'll see that they're set up very well to commit extortion. Okay, now it's time to give an example of how an administrative agency violates the law in many ways. This is a real-life example that really happened to someone. So suppose that you're just going along in life, doing your normal routine. Then one day, out of the blue, you get a letter from the state tax board. They tell you that because they noticed you're paying a mortgage, you might owe them taxes. They ask you to fill out a form to see if you do owe taxes. Well, you know the law and you realize that fishing expeditions are unlawful. No government agency can say, well, you might owe us something, so give us more information. That's prohibited by the Fourth Amendment. Therefore, you file the letter in the round file because you don't owe them any taxes. Again, the Fourth Amendment prohibits fishing expeditions or demands for information without probable cause. And by the way, where did the state tax board get your mortgage information if you didn't give it to them? But after trashing their first unlawful request, you get a second letter from the state tax board in which they threaten to bill you thousands of dollars that you do not owe. Remember, you don't owe them any tax. It just so happens. But they're going to bill you $9,564, they say, because you didn't comply with their unlawful request to provide them information. In their letter, the state tax board says that it has used a statistical model to determine what is essentially a totally fictional income for you, and then it'll assess taxes on that totally fictional number using a tax rate that it has unlawfully established. Because remember, no administrative agency can make the law. They can't create taxes. They can't set tax rates because only legislature can do that. But they've done it anyway. Now, in England 3 centuries ago, the English Parliament prohibited the king or anybody outside of Parliament from establishing taxes or tax rates. 3 centuries ago, the English prohibited what our state tax boards are doing today. State tax agencies have been making laws illegally for decades. And no branch of government is permitted to assess fees, fines, or penalties based on guesses, hunches, or fictional statistical models. They can only assess fees and fines based on facts. But if you don't comply and fill out the form that they are unlawfully demanding that you send in, the state tax board will bill you for this fictitious tax bill that they've created. And if you don't pay it, they will simply siphon the money out of your bank account using a lien. So here are the 6 ways that this state tax board has behaved unlawfully, and I would say criminally and fraudulently. So I hope you've enjoyed this video, and now by the end of it, you understand why the administrative state and administrative law is profoundly unlawful and unconstitutional and must be abolished forever from our nation.